Hello and welcome. You're watching CNBC-TV18 and we are live on our social media handles. It's a historic day in the Supreme Court as the top court struck down the electoral bond scheme. To address this issue and simplify the Supreme Court verdict, I'm joined by my colleague Ashmit on the broadcast. Ashmit, thank you for joining us. So Ashmit covers the legal beat for us and has covered this case particularly extensively. Ashmit, for the benefit of our viewers, let's start with the basic question. What are electoral bonds and why has the Supreme Court called them unconstitutional?
Well, to begin with, a very good evening to you, Archana, and a very good evening to all of our viewers. This is, of course, a landmark verdict coming in from the top court from no less than a 5-judge constitution bench of the apex court. It will have far-reaching consequences. We'll discuss that over the course of this video. As to Archana's question, the basic at the heart of it, well, electoral bonds is essentially in the nature of a bearer bond. What it does, what it did now after the Supreme Court verdict was that any Indian individual or an Indian entity like a company could approach SBI, the State Bank of India. It was the only bank authorized to issue these bonds. I could purchase these bonds and then subsequently use these bonds and deposit them with the political party for making donations. So that is, in substance, the broad idea that was backing the electoral bonds. There were a number of concerns, however, regarding how this system operated, and these concerns primarily stemmed from two counts. Number one, the right to information of the voters, and number two, the nature of corporate donations. I'll address them one by one. The Supreme Court, number one, had the issue with the right to information. The centre had been arguing throughout that, look, the donors who are making these contributions, they want to be protected against any political vengeance, and therefore that confidentiality is important. However, on the other hand, the voters were saying, the petitioners rather before the apex court had been saying that, look, to be able to exercise our right to vote, to be able to make an informed decision, it's important to know who are the parties that are getting funds from which areas, from which persons, from which entities. That was critical in making that decision on the ballot. And well, that appears to have been a concern that was has been upheld by the apex court. The Supreme Court did in fact hold that the right to information is critical, that going ahead, any decision that needs to be made by the voter needs to be supported by this data, by this information, and therefore there is a need for further disclosure. So that's as far as the right to information is concerned. On the other ground, or as far as corporate donations are concerned, this was again an area where the apex court expressed concern. The Supreme Court said that, look, any corporate entity that is making donations to political parties, it's not really, it is in the nature of a business transaction. Those investments, that donation that is being made is in the nature of an investment towards a very pointed target of achieving a policy objective. Now, with that in mind, there is that bogey, there is that possibility of quid pro quo, and therefore to address that, the Supreme Court said that this entire mechanism that we have currently operating doesn't provide for disclosure, again, provides for unlimited corporate donations, provides room for quid pro quo, and therefore, on these grounds, in simple terms, the Supreme Court striking down the electoral bond scheme.
Right. So, Ashmit, if I've understood you correctly, so electoral bonds, in a simplified way, is a way by which political parties make money, but there was no transparency as to who was donating how much to which party. Am I correct?
Indeed, that was the big pain point here. There were changes that were brought about in the IT Act, in the Representation of People's Act, in the Companies Act, which essentially provided for a corporate veil, for a political veil. There was no requirement on companies to disclose. There was no requirement on political parties to disclose. And this was a stretch from the earlier regime, which, despite all its flaws, did provide for these checks and balances, provided room for disclosure, which wasn't there in the electoral bond scheme, right. Something that the Supreme Court was clearly not too happy about.
Okay. So, do we have any data available as to which party got how much by the way of electoral bonds?
Well, what's interesting is that this data with respect to how much a political party is getting is not really under wraps or undercover. That data is available. All political parties, most political parties do release that data. It is accessible publicly. So to that count, just to give you the broad numbers here as to how this was snowballing, the electoral bonds were snowballing between March of 2018 and January of this year, which is 2024, bonds worth 16,500 crore rupees had been purchased. And these bonds were then distributed between various parties. As to who the biggest beneficiary was, well, the BJP clearly pocketed a lion's share, that's 6,500 crore rupees. The Congress was a distant second, coming in at about 1,100 crore rupees. And the party immediately after that, in third place, was the Trinamool Congress, which again also came in at about 1,090 crore rupees.
Right. So, Ashmit, another big question is that elections are around the corner. How does this verdict impact political parties? Does the funding to these political parties stop immediately?
Well, the answer to that is no. Electoral bonds, while this was a fiercely contested mechanism, it wasn't always the only means of making transactions, of making donations. The regular financial instruments, which is your checks, your bank transfers, your cash transfers, all of those routes, all those mechanisms were in fact available. There are, of course, different regulatory mechanisms when you make donations on those through those instruments, but those instruments were always available, even under the earlier regime, even now, even with the electoral bond scheme, those donations could still be made. Now that bonds are being suspended, are being done away with, we can go back to that regime. Those financial tools are available. So as far as people who are actually interested in supporting political parties and certain political ideas and agendas, that is still accessible, that still can be done materially. It should not have any major implications in terms of how much funds a political party can garner. But yes, on the electoral bonds front, that chapter is closed for now, that the apex court has shut firmly.
Right. Ashmit, another important aspect is that the Supreme Court...
And if I can just add one more element to that, if I can just add a little more color to that, even under this current regime of electoral bonds, which we had as of this morning, even under this regime, certain political outfits, such as the CPM, which was in fact CPIM, I beg your pardon, which was one of the petitioners in this case, was on record the only party that was not accepting donations through electoral bonds. The other instruments were available, they continue to be available, and those are mechanisms which will continue to operate even after the Supreme Court judgment.
Yes, I was going to ask you what happens to other political parties, those who have criticized electoral bonds. Have they been accepting electoral bonds as well, or do we have any idea about that?
Well, electoral bonds across a few players such as the CPIM was broadly accepted because that was the broad tool being used by a lot of large donors to make contributions. So towards discharging their political functions, yes, political donations were being accepted through electoral bonds despite being criticized. But nonetheless, of course, now all of that will change. The Supreme Court has shut the door as far as electoral bonds is concerned. So now we go back, we hark back to the earlier regime, and therefore there are a whole slew of other questions as to what is now the shape of an electoral donation mechanism that we have. What does that entail? These are, of course, questions that now need answers.
Yes. Another important aspect of this verdict was that the data will be made public. What can we expect from the data? Because it is going to concern both the donors, I mean the corporates and the voters as an individual. There can be concerns. Don't you think it's a conflict between right to information and right to privacy?
Well, it's interesting. That's a great question that you're asking, because this was the very question that was the heart of this entire dispute at the apex court. The centre had been arguing exactly this, that look, as far as donors are concerned, if those names become public, then there is that potential and that scope of political vengeance, and therefore there is a need to protect these donors. There is a need for confidentiality. There's a need for privacy. However, that right to privacy then competes with or is pitched directly against the voters' right to know. How do you compare that? Because the voters are claiming that, look, any electoral decision that needs to be made for a participative democracy that India is, it requires an informed decision. It requires the voters to be aware. I need to know that if I'm voting for a certain MP or a certain political party, where is that party drawing its funds from? Where is this party drawing its money from? Does that cause bias in its judgment? Does it cause bias in its policy decisions? I need to be aware of those decisions. And clearly, the Supreme Court has held in favor of the latter, saying that as far as the right to information of voters is concerned, it squarely trumps the other right to confidentiality. And in fact, the Supreme Court records as a part of its order that, look, electoral bonds places undue restrictions on these access to information. There's an unnecessary close down on disclosures which these electoral bonds introduce, and therefore this is unconstitutional and not permissible. So clearly, the Supreme Court siding in favor of the right to know, the right to information versus the right to confidentiality, the right to privacy of a donor.
Right. Ashwin, the central government was criticized a lot by the way it introduced electoral systems into the system, into electoral bonds into the system. Now, can the government challenge this decision? What happens next?
Well, like in the case of any Supreme Court judgment, you always have the legal remedy of a review petition. You can always file a review petition. After the review petition, there is also the possibility of filing a curative petition. But that is, while it is a remedy available, in very few instances have we seen the Supreme Court double back on its own decision when it is hearing a review petition or a curative petition. It is few and far between. So safe to assume that this is, of course, the lay of the land, which has been now placed before the apex court. This is the way, the law of the land, the way it will operate. The other possibility that some legal eagles have been dwelling on and have been talking about, and we've been asking various lawyers, is that, is it possible for the centre to go back to the drawing board, saying that, okay, this is a judgment that doesn't favour our policy. Can we then now come out with an ordinance that will nullify the Supreme Court judgment? That's one question that we've been asking. And the answer that we've been hearing from many legal experts is that that will be fraught with legal problems. The Supreme Court in various of its various rulings has said that Supreme Court judgments cannot be nullified by a piece of legislation. That is simply not tenable. So that is a broad view, a broad consensus that appears to be emerging, that given that any ordinance or any law that is brought about to nullify this judgment would be fraught with a lot of criticism, fraught with legal complications. The centre, the understanding that appears to be developing is that the centre is likely to avoid that route. But of course, speculation here. It's difficult to give a definitive answer as to what decision the government will take. But clearly, the view that legal experts are giving is that that is perhaps a path that the centre should not tread on.
All right, one final question, Ashmit, and a tricky one. The Supreme Court called this unconstitutional. Electoral bonds are unconstitutional and they must be stopped. But what happens to the electoral bonds that were issued in the past in retrospect? Will there be any change in that, or what happens to that money?
Well, the Supreme Court judgment is not retrospective. So what that means is that even though the electoral bond scheme has been held to be unconstitutional, there is no order for disgorgement. There is no order by the apex court that says that, look, because it was illegal, all the funds that you've managed to get in the last 6 years, you need to give it back to the donors. That's not happening. What the Supreme Court has done is that it has said prospectively that this is not a scheme that we're happy with. This, we cannot permit this going forward. The only caveat is that this 15-day, this period within which this case was being heard and being decided in the last few months, any electoral bonds that were issued in this period which are still pending, that needs to be returned. That is the only limited caveat. But otherwise, there is no requirement on these political parties to start returning their funds. But this is something that will operate prospectively. The bonds cannot operate. The bonds cannot be issued. And therefore, now we go back to the earlier system.
Right. And what is the date to make this data public by the Election Commission and the State Bank of India?
Well, the Supreme Court has given a tight deadline, March 6th, for the State Bank of India. That's the deadline by which they have to furnish all the donor details, all the donee details. So who's buying these electoral bonds and which parties are encashing these electoral bonds? All that data will need to be furnished by the State Bank of India to the Election Commission. That's by March 6th. And within a week of that, that's by March 13th, the Election Commission will have to publish it on its website. So that's a key date to watch for. We'll, of course, begin to get a lot more information as to who the donors are and which the political parties have been attracting which donors.
All right. Thank you so much, Ashmit. The clock is ticking and all eyes will be on this data. I hope our viewers have been able to understand what the electoral bonds are and what the Supreme Court verdict means. Thank you so much for joining us on this YouTube Live.